My name is Ostika Das and you're watching LiveLaw. Welcome to another episode of Courts This Week, where we bring to you the most pertinent legal developments that took place last week across the country. Let us begin with a very important development coming out of Gujarat. The Gujarat High Court quashed a 2016 Central Information Commission order directing the Gujarat University to provide information regarding degrees in the name of Prime Minister Narendra Modi to Delhi Chief Minister Arvind Kejriwal. The university argued that it was holding the information in a fiduciary capacity and was not liable to disclose it as per Section 8(1)(e) of the Right to Information Act unless the larger public interest warranted its disclosure. Not only did the bench accept this argument, but it also imposed a cost of Rs 25,000 on the Delhi Chief Minister and Aam Aadmi Party leader. The Supreme Court dismissed UP government's plea against a High Court direction to provide a job to a family member of the Hathras crime victim. The High Court had also directed the government to relocate the family from the area. A bench led by Chief Justice D.Y. Chandrachud was surprised that the government decided to challenge this order in the first place. The Chief Justice told UP Additional Advocate General Garima Prasad, and I quote, "These are facilities provided to the family. We should not interfere. The state should not be coming up in these matters." Can a woman be summoned to the office of the Enforcement Directorate? The Supreme Court has agreed to consider this question in a plea by K. Kavita, a leader of Telangana's ruling party Bharat Rashtra Samiti and the daughter of Chief Minister K. Chandrasekhar Rao. The MLA representing the Nizamabad constituency has been issued summons under the Prevention of Money Laundering Act in relation to the Delhi excise policy case. A month after the Delhi High Court upheld the validity of the Agnipath short-term military recruitment scheme, the Apex Court has agreed to hear a petition challenging the High Court's decision. Under the scanner is the government's tour of duty style scheme that allows Indians between the ages of 17.5 and 23 to apply for the armed forces and be inducted for a tenure of 4 years. Once again, the Supreme Court has refused to entertain a petition seeking uniform age of marriage for men and women. Currently, while men are permitted to marry at the age of 21 years, women are permitted to marry at 18 years of age. In January this year, the top court had dismissed another petition with the same prayer. Chief Justice D.Y. Chandrachud had said that in matters like this, it would be prudent to defer to the wisdom of the Parliament, which was also a custodian of the Constitution. The Supreme Court has allowed Uttar Pradesh local body elections to take place with OBC quota. At the heart of the controversy is a direction of the Allahabad High Court to the State Election Commission asking it to notify the urban local body polls without reservation for other backward classes. The top court has already issued a stay on this direction earlier this year. The Supreme Court restrained the Delhi Urban Shelter Improvement Board, the Delhi Police, the Delhi Development Authority and all other authorities in NCT of Delhi from demolishing temporary shelters for the homeless, or as we should be calling them, the unhoused, without getting the prior permission of the court. These orders were passed with special regard to the temporary shelters built at Geeta Ghat to accommodate unhoused individuals suffering from tuberculosis, orthopedic disabilities and mental health conditions. As instances of hate speech become more and more common, a Supreme Court bench of Justices K. M. Joseph and B.V. Nagaratna expressed their anguish over the state's failure to take prompt action to address this problem. Justice Joseph was visibly angered at the government's apathy and said, "State is impotent, state is powerless, it does not act in time. Why do we have a state at all if it is going to remain silent?" The bench was hearing a contempt petition against authorities in Maharashtra over their alleged failure to act against hate speeches during rallies. Earlier, the bench had passed a slew of directions with respect to the processions undertaken by Sakal Hindu Samaj. In a path-breaking judgment on bail jurisprudence, the Supreme Court has held that undue delay in trial can be a ground to grant bail to an accused booked under the Narcotic Drugs and Psychotropic Substances Act, despite the rigors of Section 37. Let us understand this simply. Normally, bail is a rule and jail the exception. However, special acts such as NDPS Act, UAPA limit the right of an accused to be granted bail by laying down additional conditions. In a nutshell, getting bail under UAPA or NDPS Act is tough business because of these conditions. Section 37 of the NDPS Act, for instance, lays down a twin condition for the grant of bail, namely, first, the court must be satisfied that there are reasonable grounds for believing that the accused is not guilty of such an offence, and second, the accused is unlikely to commit any offence while on bail. The bench insisted that even restrictions contained in special acts had to be considered within constitutional parameters and in light of the fundamental right of an accused to speedy trial. Any restriction on judicial discretion to grant bail would pass muster only if the trial itself has been expedited. In this case, a man accused of peddling ganja had already been in custody for 7 years when he was finally granted bail. In an interesting case on Hindu law, the Supreme Court gave two daughters the benefit of the progressive 2005 amendment, which was passed while the partition suit filed by them was pending. To put it simply, this amendment recognized equal co-parcenary rights for daughters. The court reiterated that during the pendency of a partition suit, the parties can seek the benefit of an amended law if the final decree has not been passed. The Supreme Court dismissed a public interest litigation petition seeking that the entire animal kingdom, including avian and aquatic species, be declared as legal entities having a distinct persona with corresponding rights of a living person. The PIL was filed by an NGO with the objective of preventing animal cruelty by strengthening animal protection laws in the country. In the backdrop of Kerala's elephant tragedy, the sale of dog meat in Nagaland, and other such incidents, the NGO insisted that it was important to consider the question of whether the existing laws in India are sufficient to protect animals from possible abuse and cruelty. However, a bench led by Justice B.R. Gavai said that this petition could not be considered under Article 32. In a notable development, a death row convict who had spent 28 years in jail was released by the Supreme Court after he was found to be a juvenile at the time of the offence. A trial court and the High Court had awarded him death penalty for the murder of 4 people. Shockingly, during the appellate proceedings before the top court, it finally came to light that the convict was only 12 years of age when the offence took place in 1994. Project 39A of National Law University, Delhi provided legal aid to the now released convict. Thank you, and keep watching Courts This Week for more such updates. If you found this video useful, don't forget to like, share and subscribe. Hit the bell icon to get a notification whenever we upload a video. I'll see you again next time.